Kelly Lekaise, a second-year candidate attorney from POPIA attorneys in Parktown, Johannesburg. Today, I will be discussing reporting obligations under POPIA and exactly what kind of breaches need to be reported to the Information Regulator. Section 22 of the Protection of Personal Information Act requires that where there are reasonable grounds to believe that the personal information of a data subject has been accessed or acquired by an unauthorized person, the responsible party must report this to the Information Regulator and to the data subject. This section is wide enough to include a data breach from a malicious hacker to a scenario where a colleague mistakenly sees the health information of another employee on human resources computer. Both are reportable instances of breach and must be notified to the Information Regulator. In contrast, under the GDPR, organizations are only required to report a breach where it is likely that the breach will result in a risk to the rights and freedoms of the data subject. Therefore, when the breach is of such a nature that it poses little to no risk to the rights and freedoms of the data subject, it does not have to be reported. The organization must undertake a risk assessment that considers the type of breach that occurred, whether this was a confidentiality breach, integrity breach, or availability breach. Whether sensitive data was breached. This information includes personal information of children, biometrics, racial information, and health information, the amount of data that was compromised, and the number of data subjects that were affected. Where the breach is likely to be of a high risk to the rights and freedoms of the data subject, this breach must be reported. Where it is determined that the breach is not notifiable, the GDPR requires that the organization records the breach in a breach register. This threshold, as laid out in the GDPR, is not available under POPIA. The consequences of this is that, under our current law, any kind of unauthorized access to personal information must be reported to the Information Regulator and to the data subject, even when little to no harm has been suffered. Failure to do so may attract some hefty penalties from the Information Regulator. Thank you for watching my video. If you would like to see more, check out our social media links below. Until next time, bye.